Hi, everyone. Welcome to our second topic to cover for employment law, and that is employment discrimination law. Because your homework assignment this week is to do an individual project on a specific employment discrimination law topic, I'm not going to go as in depth on this PowerPoint because I'm leaving a lot of this work up to you. So take a look at the assignment if you haven't done so already to see what your task is, and you'll be able to choose one of the topics. But I'm going to go over some basics here. Just by way of remembering, employment discrimination laws are exceptions to employment at will, because these are reasons that we are not allowed to terminate someone for reasons that are based in discrimination. For discrimination laws in employment, there's a combination of federal and state laws. Primarily, what I'm going to focus on in this PowerPoint are the federal laws, because those are the really big ones, but every state has their own set of discrimination laws as well. I also want to make reference to the federal agency and that is in charge of handling discrimination cases, and that is called the EEOC, the Equal Employment Opportunity Commission. There's also a state agency that handles state discrimination cases. In Massachusetts, ours is called the Massachusetts Commission Against Discrimination. When we talk about employment laws, and specifically employment discrimination laws, we use a phrase called protected classes or protected categories. In other words, what categories of individuals are protected from discrimination in the workplace? And here's a hint. We all fall into protected categories. For example, gender is a protected category. Everybody has a gender, or even if you identify as multiple genders, that's still being in a protected class. So you'll see as we go through that everybody falls into these protected categories or protected classes, but that is how we speak of the protections of employment discrimination laws. The first law I want to bring up is actually the most significant of the federal laws. And one of the assignments, if you choose Title VII as your project, you can delve deeper into this topic. Title VII of the 1964 Act, a Civil Rights Act, is a federal law. It is literally the preeminent law that extended protections in the workplace to employees based on discrimination. Now, in the law says that employers cannot discriminate against employees on the basis of, and these are the protected classes, race, color, religion, sex, and I put an asterisk there for a reason, and national origin, so the country that you're from. So these are the original categories as stated in 1964, which means if an employer makes an employment decision to terminate someone based on the color of her skin or race or national origin, and that is the basis for the termination or the basis to not hire someone, that is discrimination. Interestingly, Title VII also recognized two different kinds of discrimination. So if you're choosing this for your project, I'd like to hear more about it, both disparate treatment and disparate impact. Disparate treatment is more like identifying and singling out one person based on her religion or her race and saying, I don't want to hire that person because she's Jewish or she's a Muslim. Whereas disparate impact is a neutral policy put into place, so it does not appear to be discriminatory, but it disproportionately impacts one of the protected classes. So if you're doing this, I want to hear more about it. And if not, look at the example in your textbook about a disparate impact policy. So why did I put an asterisk over the word sex? Well, in the original 1964 Act, the word sex meant only gender. So that is originally, as the courts would interpret it, it meant gender discrimination. So not discriminating against someone on the basis of being a man or a woman. That is how the courts interpreted the word sex in the law to mean for many decades. What is interesting is that in more recent decades, there were a number of court cases all over the country where individuals who are gay or lesbian or transgender have been terminated or not hired from their positions on that basis. Now, until just June of 2020, there was no federal law that extended a protected class to individuals based on sexual identity or sexual orientation. There was no federal law. In other words, another way of saying that is that it was not illegal or it was legal to terminate a person based on their sexual identity or orientation. and there was no discrimination lawsuit. Again, remember the original 1964 law said sex discrimination, and until this year, sex was always interpreted to mean only gender, male or female, and that was it. Now, some states have and still have laws extending that protection. For example, Massachusetts has a state law prohibiting discrimination on the basis of sexual identity and sexual orientation. But there was never another federal law passed. Remember, think back to what we did earlier this semester. Federal laws have to come from US Congress, and Congress did not pass any amendment or any new law extending sex discrimination protection to these classes. But this is yet another topic that someone can research for their project, is this particular area of law, and tell us more about these recent Supreme Court cases that did extend the word sex to include these protected classes. Actually, more than one case. So really, really interesting. Okay, a little bit more about what is in Title VII. You saw that it actually also includes you cannot discriminate on the basis of religion. So there's two parts to religious discrimination. And again, this is another topic. So again, look through your topics for the project. Religious discrimination could include discrimination based on somebody's religion. Again, for example, I don't hire a person because she's Jewish or because she's Muslim. That would be discrimination. That's, I think people, really understand that one. The one that's tougher for religious discrimination that is also part of the project is something called religious accommodation. For example, what happens if a person says that she can't work on Sundays because Sundays is a religious holiday or, a Sabbath day and a day of rest. And so you might want to hire me to work at the grocery store or work at the mall. I'm applying for a job. But I tell my employer I cannot work on Sundays because that is a religious holiday. Does my employer have an obligation to accommodate that request? Think about it from an employer's perspective, right? I mean, what if all your employees came up to you and said, well, I need Saturdays off, and this one says I need Sundays off, and the other one says I need all these other holidays off? That's a lot to put on the employer. So where do we balance the rights to be free from discrimination from religion, but also to honor that fact that we need employees in the workplace? So the law says that an employee can make a request for what's called a reasonable accommodation. So it's not like just because you say, oh, this is my religion, I get the day off. That's not automatic. The request for the time off or whatever the accommodation might be must be reasonable, and it must not place an undue burden on the employer. So we also see examples not just for time off, but people who might want to wear men who might want to grow a beard because that's part of their religion, but the employer says, no, you need to be clean shaven. That's another example of religious accommodation. So again, the two parts to religious discrimination includes the discrimination piece, but also how to accommodate a religious request. It's not automatic. Okay, the next one that I want to bring up is sexual harassment law. So sexual harassment law does flow from Title VII. This is yet another topic that you can choose for your project. It flows from Title VII from that clause we mentioned earlier, sex discrimination. Discrimination on the basis of sex is where sexual harassment laws come from. Now, remember here, we're talking about sexual harassment on the civil side. So as someone who goes to work and feels harassed in the workplace and either wants to quit her job or file a complaint against their boss, that's the civil side of sexual harassment law. Sexual harassment, if it involves assault or touching of another person, can also involve a criminal case as well. So just keep those aside for a second because we're going to focus here on the sexual harassment in the civil context. There are two types of sexual harassment. Again, if you choose this as your topic, I want to hear more about these. Quid pro quo. That is what happens when a boss turns to her employee and says, I will promote you, but only if you go on a date with me. Or I will give you the raise that you're looking for, but only if you perform sexual favors for me. That a quid pro quo means an exchange. So I will, give you what you want in your job, but I want something in return. That is a form of sexual harassment. The other type of sexual harassment in the civil context is called hostile work environment. We see this come up in other contexts as well. But hostile work environment is not the same thing as an exchange being demanded in the workplace. Hostile work environment means that a person is made to feel uncomfortable on a sexual basis because of jokes or other comments being made in the workplace. So that's called hostile work environment. An example that we can see of sexual harassment laws playing out in the civil context has been the explosion of cases through the Me Too movement, where employees are coming forward saying, yeah, that happened to me also in the workplace. Again, some of those have led to criminal investigations, but here we're focused on the civil side. The next law I want to mention is age discrimination. I did not create a separate project on age discrimination because it's kind of a smaller case. But there are discrimination laws protecting discrimination against individuals on the basis of their age. Now, here's a fun little fact. This law only protects older persons. So if you are a young person and you think that you have been discriminated against in the workplace based on your young age, maybe someone thinks, oh, you don't have enough experience yet, or you can't possibly understand this because you're too young, that is not a basis for a lawsuit. Age discrimination is only a basis under federal law for individuals who are 40 years old or older. There's a really interesting case in your book about an older guy, 52 years old, who worked at Google and felt that he was discriminated against because people made a lot of remarks about his age. So take a look at that one. But age discrimination in employment, the magic number, 40 or higher. Okay. Another one I want to bring up that is a project you can work on is the Americans with Disabilities Act. This is a massive law, so I would not expect anyone covering this for their project to cover every aspect of the ADA. This is also the law that gives us accommodations in public places too, for people to just go about and do their business. But here we're focused just on disability discrimination in employment. So it's really important to remember that when we talk about disability discrimination, when we say a disabled person, we're using the definition from the ADA. If you work in a medical field or in a school, there's a lot of other definitions of disability, but I want you to take a look at your book and see what the definition of disability is under the ADA. So we're talking about a significant impairment on one or more major life activities. So that's what we mean about the definition of a disabled person. And there's some really interesting discussion about who falls under a definition of disability. So if you're doing this one for your project, look at some really interesting cases about who is disabled under the ADA. So just like with religion, the ADA has issues of discriminating against somebody based on their disability, like I'm not going to hire you because you don't see very well or you don't walk or you have a disability. But we also have the question of undue burden and reasonable accommodation. Those come up here too, because you could have a disabled person who's been hired but now needs an accommodation, like maybe a special computer screen to be able to see better, or maybe time off to go visit doctors for appointments. So again, we have that same balance that we see with religious discrimination, we see with disability as well. That a person with a disability can make a request for a reasonable accommodation, and the employer must honor that request if the accommodation is reasonable and does not place an undue burden on the employer. Okay, last but not least, I know I'm going through this really fast. I want to mention something called the bona fide occupational qualification. This is an exception to discrimination law that actually allows businesses to discriminate. A really good example would be a church that is only hiring a priest. The church can demand that that priest be of the Catholic religion, right? Even if a Jewish person applies and the employer says, the church says, well, I don't want to hire you because you're Jewish. Well, that certainly sounds like it would be religious discrimination, but it's not here, because with bona fide occupational qualification, it means that you have a genuine, important reason that this person can be discriminating in their hiring practices. It's very, very limited. Okay, quick overview. I look forward to your projects.